just ring
See the release first. Have you guys got it before we start? Sorry, it's just Okay, so what I've just put out is a press release confirming that today Cabinet has signed off on the policy for monitoring deported offenders when they return back to New Zealand. I've said for some months now that it's my intention to have a regime in place in New Zealand that ensures that when offenders are returned to New Zealand, they are subject to the same sort of monitoring and oversight and supervision that they would have been subject to had they served their sentence in New Zealand. And what we've been doing is trying to devise a regime that allows us to put that sort of system in place, bearing in mind that they won't have gone through a New Zealand parole board process where a lot of those conditions are worked through. So we've had to balance both ensuring that the process is simple and easily applied the minute these offenders come across the border, that it's proportionate to their offending and their risk type, but that it also maintains sufficient flexibility in the system to deal with specific risks in each case. And so what we've come up with is a regime that will apply to any offender who is deported back to New Zealand within 6 months of their release date, in the same way that conditions would apply off the release from prison. We will need this to follow on from a sentence and effectively replicate what would have been their parole conditions. That it will cover them if they have served a sentence of more than 1 year in duration, and how long it applies for will depend on the length of that sentence. So it's a graduated regime. You just let me check my notes. So if they're sentenced to between 1 and 2 years in prison, it is 6 months of post-release monitoring conditions. If they're sentenced to between 2 and 5 years in prison, it is a year of monitoring in New Zealand. If they're sentenced to more than 5 years in prison, it is 2 years of monitoring, and if they're sentenced to life imprisonment or an equivalent, it is 5 years of monitoring. Now, what happens in those monitoring conditions mirrors the New Zealand standard conditions of parole and the release terms under the Sentencing Act, which effectively requires them to work with the probation service to report in and to be subject to probation orders around where they can live, what sort of job they can have, and who they can associate with. What we've said, though, is that if specific additional conditions are required, then corrections can apply to the district court to have whatever specific conditions are required in that case. So the standard conditions will apply automatically as they land at the airport, and they'll be served notice of that. Any special conditions will go to the court and have to be approved by our courts. Under this regime, our police will also be able to require them to provide fingerprints, photographs, names, aliases, date of birth and other standard information. And if they have an offence that would be a qualifying offence in New Zealand under the Bodily Samples Act, to also require them to do a DNA swab. So in all instances, we are trying to replicate the sort of oversight that we would have had they been convicted in New Zealand. And as I've said, we also have the ability to require special conditions. And what we've done there is if an offender is returned to New Zealand after more than 6 months has happened since the end of their sentence, but they are still being monitored in the country that they were deported from, then again, corrections can go to court and seek special one-off monitoring conditions. So, for example, they may have been released from prison 2, 3, 4 years ago, but still be subject to monitoring, in which case we can still go and seek specific conditions in New Zealand. So what I think we've come up with is a fair balance between proportionality, between ensuring that we're not looking to double sentence someone for the same crime, but to effectively replicate the sort of oversight and monitoring that they would have had they been released from, say, an Australian jail and stayed in Australia, or equally if they'd been convicted in New Zealand and subject to our parole board. My intention is to get the bill passed as soon as I possibly can. It has to go off for drafting now, and I'll be working with the other parties of Parliament to try and seek their support for expediting the process of the passage of the bill.
Minister, does this only apply to criminals within 6 months of their release from custody overseas? So if they're outside of that 6 months, do they still have to submit to this?
The standard conditions will, so the automatic regime that applies to them straight away will apply if they've been released within 6 months. And by release, that includes any period that's spent in a detention centre or the like, because effectively what this is doing is replacing release conditions. So when you leave prison, you go into a release regime. If, however, as I've said, they were having ongoing monitoring in the country they've been deported from, there is not an automatic regime, but there is an ability for us to go to court and get conditions imposed. And the reason for that distinction is that we have to balance between a case where someone might have been convicted for something 2 or 3 years ago, has been living perfectly adequately in the community, has got on with their life, has finished their sentence and their monitoring, and we don't want to automatically impose that if it's not necessary. Sometimes it will be, but we have to do that case by case.
Yeah, so for anyone beyond 6 months, so because we've seen a lot of the examples of these people, some of them haven't, been in jail for a long time, they won't necessarily be subjected to this.
Not necessarily, but we have that option if it's appropriate. So what we've got to be mindful of is there are, when you're talking about Australia, which is where most of the discussion is, 2 categories of people being deported back to New Zealand. Those who are being deported having been released from prison, and those who are being deported on bad character grounds. Now, bad character, they may have been convicted some years ago, they may never have been convicted. What I've got to be careful of is that this regime is designed to be the equivalent of our parole board and probation service. So we're not looking to impose a bunch of conditions on people just because they had their visa cancelled and were returned. It is intended to replicate the sort of conditions that you would see either in Australia or New Zealand on release from prison, which is why we've linked it to the release from prison with a backstop if we need to in some cases.
Why has it taken so long? I mean, you've known since December.
Yeah, well, look, in December it was very unclear exactly how it would apply and where it would be applied to, and what we have said all the way through is that our priority has been getting, first of all, the information flowing to New Zealand as these people arrived, so that we could assess the sort of people being deported, the type of risk profile that they posed, and design a risk system and a management system that was appropriate. That's been my priority, that has been the most important part, and as you know, as we signed that off a couple of weeks ago, now that we have that in place, we have the register in place to track the information as it comes over, we're now in a position to use that information to design the appropriate risk management for each of these prisoners. So that was the order in which we needed to do it. Information first, so we can assess the risk, so we can monitor. But I will say, Corin, is that what we had as a backstop over that period is the legislation we passed at the end of last year around extended supervision orders and public protection orders, which meant that all the way through, for the most serious offenders, there has been an ability to go off and get supervision restrictions already, and that's been an important backstop. What I've wanted to have, though, is a more comprehensive regime to monitor and supervise a much wider range of offenders. That is what I'm now progressing.
Can you give some examples of those offenders that will now be caught in this?
Oh, well, look, it's a wide range, but you could well have someone who has been sentenced, I don't know, to 3 years in prison for perhaps robbery, who wouldn't have met the threshold for an ESO or a PPO, who will now return to New Zealand with a 3-year sentence. They will be subject to 1 year worth of monitoring, which means that they will have to report into a probation officer, follow the directions of the probation officer, and if, for example, they have, or in a particular case, they have special risk factors over and above just that sentence, corrections can go to court and get some additional orders if that's necessary. So corrections might say in some cases it's not appropriate that you live within 500 metres of a preschool if they had some sort of offence that was linked to offending against young children. If they needed them to attend a rehabilitation program or some sort of specific restorative or anger management or some sort of rehabilitative course, they can go to court and seek that order. So it's been the balance of what can apply automatically the minute they come across the border and the ability to go to court and seek purpose-built conditions in each case.
Minister, do you have a...
Is there any process to appeal against the automatic order?
There isn't. The only ground for appeal against the automatic order as I've drafted the framework that I want to see passed would be that if it wasn't, they weren't eligible for it to apply. So, for example, we've set out the eligibility criteria, that their sentence was of that length, that they were released within the last 6 months, that it is an offence that would be applicable under New Zealand law. So with Australia, there's not too much of an issue there, but in some countries, there are some offences that we would not treat as criminal offences, and of course they won't be subject to the regime. So if there was a suggestion that the automatic conditions shouldn't have applied under that framework, then obviously that can be challenged and set aside, but otherwise they apply as a function of law.
Minister, how many of the people already, do you have an up-to-date number, firstly, of New Zealand-born criminals in Australia who have been deported here now? Do you have an up-to-date number?
So the best number I've got is that as at last week, 167 had been deported back to New Zealand since the new regime took effect, and that there are a further 585 awaiting processing. We know that there is a backlog they are working through as they deliver this policy change from Australia. Longer term, it's hard to predict exactly how many will come in a year. Somewhere between 150 and 200 a year is our best guess.
So
What's
of
the
that
timeframe for the
165 that are here, what's happened with them? Do they get off? Can you go back, or are they getting off scot-free?
Well, as I've said, there's always been the ability to seek an ESO or a PPO. Retrospective legislation, as you know, is incredibly difficult. It's my intention that the regime will apply as soon as the bill is passed, and we want to expedite that. As I said, there will be a backstop ability in there for corrections to go and seek additional orders from the court at any time, and it may well be that that's something that can be sought for
But
offenders
still,
who are already
in the end, those 167 have avoided this regime.
Well, look, there have been offenders being deported back to New Zealand since the beginning of legislative processes and criminal justice regimes, just as we have been deporting offenders to other countries. That has always been the case. The only thing that has changed is that there is now a greater number coming from Australia. In all other cases, this is how the system has been for many, many years.
But the government knew that since December last year, and now here we have 167 criminals who've avoided a scheme that we clearly need.
Well, as I said, the number of offenders who have been deported back to New Zealand over the years it will be a bigger number than that, and that has always been the regime that is in place in New Zealand. My view is that actually we do need to have a system to monitor offenders who are in New Zealand. I wanted to make sure that as a first priority we had the information flowing from Australia. It would be almost impossible for corrections to make a sensible assessment about what sort of conditions they needed to seek until they had that information dossier. That has been the most critical part to keeping the public safe. That has been where our energy has been. That was signed 2 weeks ago.
Just in terms of keeping the public safe, if one of those, sorry, what was the number?
167.
So in terms of keeping people safe, if one of those 167 people commits a serious crime or kills a New Zealander, whose fault is it?
Well, Patrick, there is never an assurance that anyone released from prison in New Zealand or anywhere else won't go on to commit serious offending. Unfortunately, sometimes that happens. We do our best through parole, through probation services, through monitoring, through oversight, to limit and control that risk. There is never a guarantee, and we want to do the best we can to ensure that. But the most important thing in terms of understanding that risk is for police and enforcement agencies to have known the risk that these people pose. That is happening right now, thanks to the information sharing agreement we have. As these people arrive into the community, which we have no choice over, we now understand far better their risk. Without that information, how would we have had any idea what sort of conditions to seek?
Isn't it as simple as in December last year, information sharing, here's a murderer coming back to New Zealand. Why didn't you do something about it?
We have. This regime has been being designed since the earliest part of this year when I became aware of this issue. It has taken some time to work through exactly what the right weighting is, what the proportionality is, ensuring we had the balance right between not sentencing someone to effectively double sentencing for the same regime, but to try and understand the profile of who is coming back, what the numbers were, how different settings would capture different people, the costings of it, the resourcing of it. But as I've said, while we've been developing this regime, which I've had underway for some months, we have been working very hard to get that information, because I can put in place these standard conditions regime as a backstop, but the most effective way to control the risk of the most serious offenders present is to understand their risk profile, their gang affiliations, their victim behaviour. None of that would have been possible without that information. Now that we have that, this regime is meaningful.
Have any special conditions been put on the 167?
Look, I couldn't answer that question. Corrections make the decision as to whether they apply for an ESO or a PPO. They have had that power the whole way through.
So it could be none. Have the conditions been put on any of the 167?
What I'm saying to you is that since the Australian system changed, we have made sure that ESOs, extended supervision orders and public protection orders are both available to be sought for any of those offenders from the first day that the regime changed until now, and corrections make the assessment in each case as to whether that's appropriate. That's not a decision that I as a minister get involved in.
No, I know you don't.
I can't give you a number
but do you know?
I don't have information as to whether that has happened. But what I can tell you is that we have made sure that those options are available to protect New Zealanders from the most serious of these offenders. With that in place to protect against the worst, I wanted to have a more comprehensive system which required the information which I now have in place.
Do you have a break?
Any of those orders have been used?
I don't know.
Any of them that have come back?
I don't.
When do you intend having this legislation passed into law? Before Christmas?
Look, it's my intention to get it through as soon as I possibly can. What that's going to mean from today, now that we have Cabinet confirmation of the settings, it goes off for drafting. In the meantime, we're going to be working with the other parties in Parliament to seek their agreement to expediting the process. Exactly how that plays out will be a matter for the Leader of the House and the Leader of the other parties.
So it could be debated under urgency before Christmas?
I want to get it through as soon as we can, but that will depend on discussions with other parties.
Minister, are you looking to have a memorandum of understanding when it comes to sharing knowledge with any other country apart from Australia, or is Australia just the main?
Look, Australia is far and away the biggest source country for us of deported offenders. Now that we have this regime in place, of course, it will apply to offenders deported from any country. But as I've said with the Australian example, while we can impose the standard conditions automatically as they cross the border, the real value of the regime comes from understanding in depth their risk profile and then being able to seek and apply special conditions. So what our police force do through Interpol is seek information about deported offenders in each case as they can. What changed with Australia is with the increase in numbers, we needed to have a much more streamlined and comprehensive process than a simply case-by-case basis that we had before. So the regime will apply for all other countries. At this stage, I've got no information that there's a need to seek formalised information sharing protocols with other countries, but obviously that's open to us should that become required.
And will the New Zealand government be covering the whole cost, or will you be looking at recovering some of the costs from where they've been deported or where they've committed that crime?
The cost of the probation regime under the framework I've announced today will fall on the New Zealand government. These are New Zealand citizens. We've said from day one, whatever view people might have of having to receive these people back in New Zealand, we have no choice, and when they are here, it's incumbent on us to take steps to do what we can to supervise them, to monitor them, and to try and reintegrate them into New Zealand. That is a cost that falls on us.
So just in terms of the fingerprinting, will that be every single detainee that comes back here, will they be fingerprinted?
Everyone who has returned to New Zealand who's had their visa cancelled, whether or not it's off the back of the completion of a prison sentence. So under the Australian information sharing protocol, fingerprints will already be supplied. The reason we've made it more comprehensive is of course to cover all countries who may be returning prisoners to us, but also if there's ever any evidential issue in court around the fingerprint record, it allows us to have our own New Zealand source identifiable fingerprint ID and match it with the Australian records.
And the DNA sampling, that will obviously only count for, ahead of the legislation, won't it?
That's right. It will count once the legislation is in place. It will give us a legal mandate to require a DNA swab from the same sort of offenders that would have entitled us to seek a DNA swab under New Zealand law.
So those 167 will never be subject to that.
Well, the information dossiers that we're obtaining from Australia cover a wide range of information, and to the extent that those predate the information sharing regime, we're now beginning a process of working backwards and backfilling the information about anyone who'd come in before the information sharing regime to get as comprehensive a picture as possible.
But that doesn't include DNA, does it?
Well, it includes biometric matching of fingerprints, but not the full DNA swab, is my understanding.
So the DNA, these 167 potential time bombs that are out there, thanks to this, they could be scot-free on the DNA as well.
Well, of course, whether they would have been subject to a DNA sample is another question. It's not every offender who has to give a DNA sample, and what I don't know and what you don't know, Paddy, is how many of those 167 would be in that category of qualifying for a DNA swab. What I've done is made it clear that if you would have been liable to give a compulsory DNA sample under New Zealand law given your offending, the same will apply whether you offended in Australia or elsewhere.
And have you got a breakdown of the offences the 167 have committed? Do you?
No, I don't, but we do know in general, I should say, that a number of the people being reviewed or held pending visa cancellation are serious offenders. This is an area, obviously, that contains some high-risk offenders. But as I've said right from the outset, so that whole 167 have always been under the framework of the extended supervision order and public protection order regimes, which have allowed controlling the risk
they might
to be
not
sought.
have been applied.
Well, that's up to the corrections department to assess the risk of each case.
Don't know.
Well, as I said, I don't intervene in specific decisions they make.
No, I'm not asking you to intervene. Just do you know if they've been used?
No, well, I've said I don't know, but the point being
because isn't that a worry?
My job is to make sure that they have the tools to assess if there is an imminent risk of serious harm to New Zealanders that corrections have had in place right from December last year, the ability to seek those orders. Whether or not they've been justified in any of those 167 cases is a matter that corrections determines. Now, whether they've made the right call or the wrong call is a matter for their assessment. I'm not going to imply that because no orders have been sought, that means the ball's been dropped. What I've made sure, that regime is in place, and under what I've announced today, we'll have a more comprehensive
But if you'd
regime.
moved quicker, there wouldn't be 167 that you were worrying about.
Well, there'd be 167, the same people would still be in New Zealand. We can't change that. And these monitoring conditions are no silver bullet. We know that in New Zealand. We know that with the best parole conditions in the world, the best monitoring, the best probation service, unfortunately, offending still occurs. We do our best to limit it. Those 167 people would still be in New Zealand. And what we would have had in place would be a very generic set of conditions without the ability to tailor them to the incoming offenders based on their risk profile.
But you could have got something in the can, so to speak.
Well, we did have something in the can, which was a regime to protect us against the very worst offenders. What I wanted to do was make sure that we could understand exactly what the risk was to seek the right conditions. Now, I've made it clear, if you go right back through my press releases on this since I became the Minister, I've made it clear that our number one priority was to get good information from Australia about who was arriving, about what their risk profile was, to allow our law enforcement agencies to know that, to assess it, to act accordingly. Based on that, would enable me to put this regime in place. I've been developing this regime in parallel. As soon as the information sharing agreement's in place, this is ready to
So
go.
you don't believe you've
by
been caught
Cabinet.
napping on this one?
Absolutely not. I know I've been working on this since I became briefed on the issue.
But you don't believe it's a year too late? 167 people are effectively on the loose.
Well, look, the reality is that Australia didn't give us advance notice on this. We didn't know this was coming, so we had to start from December last year. Policy development doesn't happen with a stroke of a pen. We had to understand the scope of what was going on, the risk profile, the ramifications, the options open to us, any Bill of Rights implications. And I do, it's easy enough to dismiss those, but as you guys know, you've run stories, some of these offenders are pretty nasty sods. Others are people who, at least on the face of it, look to have been caught up in a reasonably tough Australian system. We have to make sure that the framework balances keeping New Zealanders safe against some pretty nasty characters and not looking to overly punish people who have been caught up seemingly in a pretty tough situation and who don't justify that sort of oversight. So we have acted, I think, to make sure we balance that right, that we get a framework in place that can react to their full risk profile, not just what the last offence happens to say, and to make sure that New Zealanders are protected against the worst risks through that period. That's exactly what we've done. I would have liked to see that information sharing agreement concluded much sooner. I've made that very clear. I've made some pretty clear statements about that. For whatever reason, Australia weren't prepared to sign off on it until 2 weeks ago. 2 weeks out, this is now signed off for Cabinet and out for draft.
So if something goes wrong, if one of these 167 commit a serious crime, it's basically Australia's fault, isn't it?
What I'm saying is that they sent them back. We had no choice. They are in New Zealand. Any monitoring system in the world doesn't protect us from harm in the same way that we're not protected from all of the dangerous criminals who are released from New Zealand prisons at various times. But we do want to have in place a better monitoring regime. We do think that will help. We've moved at pace to get that in place. And I think the balance has been struck between an appropriate, a proportionate regime and one that is able to be tailored to the specific risk profile of the offenders in
My
question.
final question, the
585 pending.
Yeah, are they in detention centres?
I couldn't tell you that. As I've mentioned, not all of the people being deported back to New Zealand are offenders, having been released from prison. A number are being on bad character grounds. That is a different regime again, because you've got people who have potentially never been convicted of an offence or some years ago. This regime is about monitoring release from prison conditions. So not all of those people will be under this system. And the exact breakdown I couldn't give you on a case basis, but look, our best estimate is about 60% deported offenders, about 40% bad character. But I haven't got a line-by-line breakdown of that number.
You mentioned Australia's delay on signing off on the MOU.
Yes.
It happened quite soon after changing leadership. Do you think that's the main reason why?
I'm sorry, I just missed some of that. Can you
Sorry,
say
it happened quite soon after a change in leadership. Do you think that's the main reason, more sympathetic ear to the problem?
Oh, look, I think in fairness, momentum had been picking up with the Australian officials we've been dealing with over the past few months. The two Prime Ministers obviously addressed it, Prime Minister Abbott and Prime Minister Key, in February of last year. We put it on the agenda for that meeting because we were frustrated that we weren't making traction to that point. From that meeting in February, there was definitely an increase in activity. It got over the line after the change of leadership, but I'm not in a position to speak to whether that was a factor or not.
Do you think it had anything to do with the blunt conversation that was had in New York? I mean, it was signed quite soon after that blunt conversation.
Look, I'm just very pleased that we finally got it over the line. It was a source of some considerable concern to me that offenders were arriving in New Zealand with scant, if any, notice to New Zealand and with very little in the way of information around what their risk profile was. That to me was the most serious threat we were facing, and that was our number one priority. We were developing this regime in the background knowing that we would need to refine it once we knew exactly how much information we could get. Exactly what led to it, I imagine it was a matter of a number of small things pushing the direction. It's over the line now, for which I'm very pleased, and as I said, we're now making sure we go back and backfill for the people who have come out so that we have a full information suite for all of them. This regime will allow us to seek conditions where appropriate with an automatic regime in place going forward.
Minister, could I just ask you quickly, do you have any concerns about Nikki Haga's bank information being given over to the police by Westpac, you are Justice Minister in charge of
Oh, look, I'm sorry, I don't have any information on that. I haven't been briefed on it.
Do you personally, are you personally concerned at all that a bank would hand over that information?
Look, I haven't been briefed on it, so I'm not going to speculate a view on something that I'm just not clear what exactly is the case.
Just back on the Australians, some of these people are being held in detention centres for